What's good, everybody? This is your girl, your favorite paralegal, aka Cassandra Lynn, coming to you today with another lawsuit. Today, we're going to be covering Miss Lauren Pisciotta versus Kanye West lawsuit that pretty much everybody has seen all over the internet. And so we're going to break down the complaint that was filed in a Los Angeles court and take a view at the court docket and see where they are at this time. And I'm not going to keep you guys that long because it is Juneteenth and I'm pretty sure people are enjoying their day. So give me 1 second. Let me pull everything up and we can get started. All right, let's get into it. I hope everybody's doing well today. Alrighty, so what we have today is Lauren Pisciotta versus Kanye West and a few other entities. This case was actually filed on June 3rd, 2024, so we're not going to see a lot of movement on this case only because it was just filed. Now, even though it is the 19th, the 3rd, you have to realize once they file a complaint, they have to issue summons, and then that summons pretty much gives a process server or the constable or sheriff the right to go ahead and serve the entities as well as Mr. West on this lawsuit. In the news, they, had a couple of more claims regarding what type of lawsuit this was, but whenever you are going to go file this in court, you have to file it under a particular case type. So as you can see, it's wrongful termination, but there are a lot of other things that she is suing Mr. Kanye West for. So he's the plaintiff, Miss Lauren Pisciotta. And then we have the defendants. So she is suing Kanye, aka Ye, Yeezy or Yee, however you say it. So Kanye West, aka Yee, Yeezy Apparel, Yeezy Construction, and Yeezy Footwear, excuse me, and Yeezy LLC. At this time, it's only going to show her attorneys because obviously she hired them to file the lawsuit. We're not going to know who Kanye's attorneys are until they file a response or an answer to the complaint that was served. Hey, LP. Yes, bless Juneteenth to you as well. Thank you for coming, and to everybody that is in the bushes. Hey, Curly. All right. Well, just listen, take it in so you guys can be updated on our boy Kanye. I like Kanye, to be honest. Sometimes he gets on my nerves with some of the things he does, but then again, sometimes he makes sense. I put him up there with like the Cat Williams and the Orlando Browns. So, but going back to the case, they actually filed this case on, as you can see, June the 3rd. And it comes with the complaint, the civil case sheet, the alternative dispute resolution, all that good stuff. I said resolution packet, so on and forth. So the complaint was filed on June 3rd. A couple of days after, I guess they needed to update the complaint. Want to just make sure. Yeah. So they just updated. I guess the way that they had it, everything was capitalized, and I guess they just changed it on a docket to show lowercase. Normally, when documents, it's always going to be uppercase in the case style, but who cares? Let's see. So a summons was issued on this day, as you guys can see, updated summons on complaint. So the citation, I call it citation in Texas, but summons in other places. So the summons was issued on June the 5th. Now, how do we know if Kanye got a copy of it besides him turning on the TV or going on the radio or the internet, finding out that he has a suit? We don't know, but normally what happens is when the sheriff goes ahead and drop off the packet that includes the summons as well as a copy of the complaint, they have to come back and then in return file a return of service, and that's just an affidavit stated that they served the party who is part of this lawsuit, so on and so forth. So we're not going to see too much action on here because I'm assuming he's already got wind of this lawsuit. We just have to wait for his attorneys to file a notice of appearance and their answer, and the case can move on. So this date here, this does not mean that they have a hearing. This just simply means it's a case management conference, which means that they have to judge as well as any of the attorneys that are on the case. They have to make sure that they come together and pretty much give out a game plan of how this case is going to move forward. And one day I'll get on here and kind of show you guys what a case management conference or a scheduling order or a docket control order is and kind of walk you through that process. So this does not mean that he has a court date on that day. It just simply means that the judge and the attorney are going to get together and they're going to work out a game plan to move this case along. Hey, Gold Digger. Yeah, say to you as well. Yeah, so what I've been seeing on this here internet is crazy. I'm like, Kanye's always getting into something, but I'm not the one who's really into the celebrity lawsuits. It just really piqued my interest, with Krishan and Base and things of that nature. So why not go into this and get all the juicy details and all that good stuff, right? All right, so what I am going to do, I am going to we're going to pull up the actual lawsuit. All right, so I did have to go through beforehand and make sure that I redact some information because I do not want, even though I'm not like the big YouTubers, I don't want anything to come back on me. So I have my fair use disclaimer. Everything that I am bring it to you guys is for educational purpose, commentary, so on and so forth. So here is the lawsuit that was filed on June the 3rd. And I'm going to kind of minimize it so you guys can see everything that she ended up suing or filing a lawsuit for. Let me turn off my. Give me a second. Okay. Turn off my ringer from my phone because I would be the one who get a phone call right in the middle of everything. Okay. So here you guys can see it. She has this complaint, or this lawsuit was brought upon due to breach of contract, wrongful termination in violation of public policy, this type of harassment, quid pro quo in hostile environment, unlawful retaliation, gender discrimination, failure to prevent harassment, discrimination, and retaliation, quantum merit, unjust enrichment, fraud, unpaid wages, waiting time penalties, failure to provide accurate wage statements, failure to reimburse business expenses, intentional infliction of emotional distress, failure to produce employment records. Whoo-wee. All these are, so 15 causes of actions have been filed against Mr. West. All right, now I'm not going to get into all of these parties and where they're from, but I am definitely going to give you guys the meat and potatoes, and you guys can take that and run with it. I'll blow it up so you guys can actually have an opportunity to see. All right, so we're going to start at the general allegations for this case. So at all relevant times, Lauren Pisciotta, that's an Italian name, is an individual who resides in Los Angeles County in the state of California. Plaintiff is informed and believes, and on that basis allege, that defendants Yeezy LLC and those 1 through 10 inclusive, and each of them were limited liability companies, corporations, and or business entities form unknown, conducting business in the state of California in the county of Los Angeles. Normally, this, as you can see, is a whole business. So it could be employees, it could be the CEO, it can be anybody in between. We usually put those in there only because if we are unaware of who those individual particulars are, then we have to label them as John Doe. So if we know exactly that there was 5 of them, we're going to do like 1 through 5, or if there's anywho's, that's why it's those 1 through 10, because she's not just including the business, she's also including the agents, the employees, so on and so forth. So she's not only suing the LLC, but also the apparel, those 11 through 20, Yeezy footwear, Yeezy construction. So those are 4 entities that she is suing. She's also including Mr. Kanye West. Now we all know he legally sued him. So if she would have put just Kanye West, or if the attorney would have put Kanye West, that would have been a whole nother thing. So anytime you're drafting a lawsuit, you have to make sure that you include all of their aliases, so that way they can't come back and say, well, you sued the wrong person. Because I've seen that a lot of times. The true names, da 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 da. All right. And so this is just language, just to make sure if anybody, so like I said, you're in those entities. So we have to include language to say If you are not the correct entity, or if we misspelled that entity, please know that we know who we're talking about and we're suing the right people. Just let us know and we can go ahead and amend the petition. That's all that is. So here's the meat and potatoes, the factual allegations to each of those 15 causes that we seen in the beginning of that. Ooh, you know what? I'm gonna I'm gonna switch up the screen so that way you guys can actually see all of it. Okay, so plaintiff has worked in the music industry for approximately 15 years. She has successfully held positions in and as artist management and representation, which is also known as A&R, marketing consultant, and project management. Due to her professional success, plaintiff had occasions to interact professionally with many artists, including, without limitation, defendant Kanye West, aka Ye. Plaintiff creatively collaborated with defendant on Yeezy Season 1 women's fashion line and placed 3 songs on Donda, Kanye West, aka Ye's 10th studio album that was eventually released in 2021. In or about 2021, defendants Kanye West, aka Ye, I'm just going to call him Kanye, an individual, and Doe's 41 through 50, inclusive, and each of them acting on behalf of themselves and acting on behalf of co defendants Yeezy LLC, Yeezy Apparel, Yeezy Footwear, and Yeezy Construction, and Doe's 1 through 10 inclusively, and each of them contacted plaintiff, requested that she serve as defendant's executive assistant, personal assistant in connection with the business affairs of all defendants herein and the personal affairs of Kanye West. So what that means is not only is she the executive assistant or personal assistant to just the personal affairs of Kanye, but she's also handling all of the business for each of those entities that we just mentioned. At the time, defendant stated to the plaintiff that he was impressed with her prior as defendant's employee, and they agreed on a salary for of $1 million per year. I might need to change my profession. Defendant Kanye West required that plaintiff was available to him 24/7. So that means that she could be dead sleep, but if he calls, she need to get up and do whatever it is that he needed her to do. In reliance upon defendant's representation, plaintiff accepted the annual salary and agreed to work for defendants, so all of his companies, as the executive assistant, personal assistant, and began doing so as a full-time employee. At all relevant times, Kanye was aware that the plaintiff maintained a strong social media presence comprised of her Instagram and an OnlyFans account, the latter of which was run entirely by an independent management company, and he did not have an issue or objection to that. So he knew that was on Instagram. She had her OnlyFans, but she had her own company that handled that portion. And so with that being said, mind you guys, he wanted her to be there 24/7 whenever he needed her. But he was fully aware that she also had her things to do. To the contrary, defendant Kanye West, aka Ye, often boasted to his friends and colleagues that plaintiff was an OnlyFans superstar. Social media presence included, but was not limited to, Instagram and OnlyFans, and content of, among other things, professional bikini and lingerie photographs, a result of professional and tasteful photo shoots. Plaintiff social media presence generated approximately $1 million annually. So pretty much she getting paid. And if you're working with Kanye and you doing your stuff on your side, you $2 million a year. Okay. Much later, in and around 2020, August 2022, defendant Kanye stated that he wanted plaintiff to be godlike, asked plaintiff to delete her OnlyFans account. Now, if you know that you are making this much money, that's going to take a dip in your income, not unless you have to pay me an extra million for the fans I'm about to lose because I'm about to get rid of this account. But anywho's, defendant agreed to plaintiff's $1 million if she did so. Oh wow. So not only is she making her salary, he agreed to pay her $1 million if she got rid of her OnlyFans account. In further reliance upon defendant's representation, plaintiff deleted her OnlyFans internet account, thereby giving up annual sums generated from such account. Kanye never paid plaintiff as promised. I am going to, this right here, if she did not get that writing, it is going to be very hard for her to prove. Like, I need you to draw up some paperwork and specifically tell me that you're going to give me $1 million if I get rid of my OnlyFans account. All right. So that's strike number one. So Kanye, I hope you have something that shows well, not Kanye, Miss Pisciotta. I hope you have something that shows that he promised you $1 million. That's crazy. Meanwhile, commencing almost immediately, defendants Kanye, an individual, and then all his business entity, and the Doe's 150 engaged in a systematic, severe, and persuasive and offensive campaign of unlawful harassment based on plaintiff's her sex, all right, meaning her being a woman, including harassment, which is in violation of various provisions of the FEHA, including but not limited to Government Code Section 12940J. Defendants' actions and each of them involved acts such as that word in front of plaintiff, oversharing intimate details, photos, texts, and videos of these acts, including without limitation acts that defendant West was engaged in, and other pictures and videos of Instagram models, current and former Yeezy LLC employees, and various men and women. God dog Kanye. Whew. Let's see what Curly said right quick. Yes, everything needs to be in writing. She's screwed if she don't have that. Kanye know that. Yep. Yep. LP said, seems there's an industry ritual to take down black male celebrities, yet some of them bring discord onto themselves. You can't sell out without facing repercussions later on. That is nothing but facts, and it's crazy. In the LA area, I really don't know what's going on, but um from coast to coast, from New York all the way to LA, what's really going on? But it's worse in LA though. Worse in LA. All right, so we have specific instances of harassment, discrimination, and otherwise unlawful conduct. So we know that the harassment was the intimate harassment, discrimination based off of her gender, and other unlawful acts. Number 9 says, moreover, and by way of example, only and not all intended to be inclusive, all acts of that harassment. The following are some of the specific non consensual, offensive, unwanted, unsolicited, unwelcomed, and unlawful acts. So I'm about to tell you guys, I skim through this and I was like, wow. So trust me, if you do not feel comfortable watching this, just hit the like button on the way out. But for everybody's hanging on in there, let's go. So Mr. Kanye sent the following unsolicited texts and videos to plaintiffs. I'm going to tell you guys right now, if there are videos, it's a wrap. It is a wrap. Text messages are a little bit different, but normally when we subpoena cell phone records and stuff like that, we don't get text messages from the individual themselves. We're going to go to your carrier and they're going to print out a list of your phone records and text messages. Because even with my plaintiffs, on the plaintiff side, I don't trust them. In a sense, if y'all listening, my bad, but it's nothing personal, just business. But I have to go to the carrier and get, whatever it is, the photos, the text messages, the call log, because you have to really pick through it with a fine comb. But I said all that to say, with the text and the video, that's crazy, Kanye. That is really, really crazy. So let's see what our boy said. Okay, yeah, maybe he was rapping. It's probably like some new lyrics. Huh. All right, I ain't gonna say the bad words, but y'all can read them. See, my problem is I be wanting to then after I want a girl tell me how hard they've been while I'm them. Then I want her to cheat on me and go get with a bigger than mine and come back and tell me the story. Then I want her to my with her best friend, or option B, my with a bad already that I then made her tell me hard she been while I was her and went somebody with a bigger behind my back and told me while I was her. Ooh, 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 ooh. Ain't that this this man clearly got some issues. Something going on. Ooh, this is interesting. We gotta get down to the juicy details because man, I used to know when he sent this because between Kim and his new chick, I'm pretty sure he had some side chick somewhere up in there. Yeah. LP, yes. Clients don't always provide the entirety of all their message. And they think that they are helping themselves and they're not. So I don't even, what's your phone number? Who's your carrier? All right. Because what happens is we can't help the plaintiff if we find out something before opposing counsel finds out. That's the whole purpose through discovery. So when we go to discovery and they request for production of records such as text messages, phone calls, all that other stuff, what happens is they will find everything. I mean, pulling criminal records. So it's always best for if you ever find yourself as a plaintiff on a case, be truthful with your attorney and them everything. I'm talking about personal injury cases, criminal case. Well, for really just for the personal injury cases, because that's more plaintiff. That's my arena. And I do criminal work as well. But plaintiff cases, civil cases are my bread and butter. But when it comes to injury, wrongful termination, all these cases, you need to be upfront. You have to be upfront. Otherwise, we can't help you because if this comes out in deposition or it comes out when they request the evidence and all these records and you didn't tell us, that can hinder your case. And we don't want to do that. Yes, Cookie. Rona said he's doomed. I was rooting for Kanye. I know it don't look too good. LP said, "Oh my, this was drastically gross and sickening." That's yeah. Ramona said, "They say he crazy. Can he use that in court of law?" What? That he's crazy? Crazy ain't got nothing to do with it. If there's tangible evidence showing that you sent these text message and you didn't pay this lady when you promised to pay this lady and all that good stuff, it ain't gonna work out. It is not gonna work out. LP exactly so they can help you or have valid reasons for what happened. Exactly. Exactly. All right. So that was one. Oh man, this man. Oh gosh. B. That was just A. B. On another occasion and multiple times and multiple other times, Mr. West asked plaintiff to get him honey, an enhancement in performance honey. Defendant required that plaintiff always have this on hand and available, and she had to deliver it to defendant in advance of defendant's encounters. This sound like Diddy, y'all. When he had everybody in the house walking around with their patches with his little pink his little pink minner. Oh my gosh. C. Kanye sent plaintiff the following offensive text. How many times you knock a ninja out in 2 minutes and they was making all kinds of excuses. They never had no blank like this. LOL. Y'all, I'm reading this for the first time. The first time I just skimmed it, but I'm reading this, you guys, so I'm going to laugh too. Kanye sent the plaintiff the offensive text. Prostitutes, I'll call them lady of the nights, always got the best. Oh man, Kanye. Lady of the nights always got the best. It's their business. Another text. One time I took Viagra and blank an A-list celebrity for 3 hours. Not sure why that thought came to me. So you just randomly texting this girl this. Next text. I'm a blank, the living dog blank out this blank off the honey. All her friends gonna need to find out where that blank with me in love. All her friends meaning, and that name was removed. LOL. Mm. Next text. You got blank's cell phone number? So he was asking about somebody's cell phone. I need him to start blanking some of my blanks. Wow. I love when blanks get the blank blank out of them and tell me about it while I blank them. You just gotta be something's going on upstairs. That is sick. Why you doing this with this person, but you want to hear about they rendezvous with another person? That's kind of crazy. Ooh, child. All right, next offensive text. Santa Barbara, but keep that room at that blank Malibu spot. Blank, the blank out of that person's name has been removed. Wish you were there. I miss my dog. NFR, I have nah for real. I think that's what that means. Need to blank these blanks. Ha. We don't even have to blank. Whoever's name was there was removed was to fire also. Another name removed, just that kind of summer. Good grief. Take a break and we're going to read that. Hey, Gold Digger. Hey. Ooh, let's see. Ramona said he was on medicine, the medicine the government gave him. Girl, what? And it's probably that when he dyed his hair gold, it got to his brain cells. Yes, child, do they all have the same membership? Man, I'm starting to think so. It gotta be the Illuminati Club or something. Curly said, "Oh my God, I can't. No Diddy, no West. What's next? I'm waiting on it too." LP said, "I don't understand why folks send text messages and other information, knowing nothing is private in this world of advanced technology." That part. That part. Curly Kiki said, "Oh no, I wanna those days." Yes. Spill the tea. Spill all the tea. Ramon said this music industry is demonic. That is like my sidetrack. My sister actually has a friend when she went to school in Howard. They were really, really close, but he ended up going into the music industry. He played the piano. He was a pianist, and he went to a mega church in DC, but he also had the opportunity to play with Beyonce on the piano, whatever. But when I say I don't know what got a hold of him, but he ended up taking a dark turn for the worse, and it's bad. I literally had to unfollow him on my social media because the things that he was putting out was straight demonic. It is crazy. It is crazy. I'm happy to be in my little simple world. Alrighty, let's go on to I. Another offensive text. I have a serious. Be honest with me. Is my blank racist? It is. This blanking racist blank of mine. I'm going to beat this blanking racist blank for being blanking racist. I'm going to stare at pictures of white women with black blank and beat the blank out of my racist blank. This racist needs to be beaten till it can't be racist no more. This ain't right, bro. After 400 years, we still at this point, the richest black man ever, beating the out of his big black blank. Boy, Kanye, boy, oh my gosh. He need a psych evaluation after this one, man. All right, so he sent the other offensive text. Jay, I just thinking back to the bowling alley, thinking of what headline could have been Ye arrested for blanking the blank out of his assistant on the bowling alley floor. Whoo child. The text was especially offensive since it suggested or insinuated that plaintiff wanted, well, one, wanted to have relations with defendant and actually had relations in course with defendant when in fact she did not want to do so and never indeed did so. Kanye West sent plaintiff a lengthy text with explicit details of his encounter with a model. This text was likewise especially offensive as Kanye closed the text with, "I did think about plaintiff when I came though." Mm. Y'all don't forget to share this. I know people want to hear about this. My poor boy. L. Kanye continually told plaintiff that he wanted a hug from her. It was continual and on multiple occasions. He clipped a photo of plaintiff and text, "Hug please." Defendant also clipped a photo of plaintiff from her social media and text, "Crazy. A blank never wanted a hug so bad." Mm. M. Kanye, in between sending videos of defendant client having relations with a model, defendant sent a text and the meme photo below to clarify what he intended and meant when he said he wanted a hug for plaintiff. I had to definitely crop this photo. Well, redact a portion of it because I'm like, bruh, I don't need no problem on my little old platform. Y'all ready? When I say I need a hug, this is what I mean. So you can imagine what's going on in this photo. So we're going to scroll right on by. So Kanye sent a photo via text. Description: two photos of a model posing in the mirror. He sent a video via text. Description of that video was a 6-second video of defendant took of a model topless, bending over and shaking her butt for the camera. He sent another video via text. Description: a 24-second video, defendant film of a model performing oral. The video was followed by a text conversation wherein defendant asked plaintiff if he should edit the video as he wanted to make sure his blank looked big enough. Another video by text, 13-second video that the defendant filmed of him having relations with a model. Another photo via text. It is a photo of a model posing in her kitchen. This was followed by another photo of the model grabbing her butt naked. He then sends a text to the plaintiff saying she crazy. We all know how Kanye talks. Video: a 30-second video of a model having intercourse with an unidentified man. Let's see. Two photos of a model laying on the floor posing in a thong and no top. Where is he getting these photos from? Another photo. First image, a text about a model wanting to see a video of him having relations with another model. Second image was a screenshot of a text conversation he had with a model telling her, I want to blank you raw. So if you anyone else, you have to wear a blank. I love blanking you raw. So Kanye, you out here not having safe intercourse? What the fuck? Third image, a photo of a model dressed in lingerie exposing her JJ and other parts where the sun don't shine. A screenshot of a photo of a model naked in her kitchen. Golly, boy, they killing my boy. Um, a photo via text, a naked exposing her butt and breast modeling his sunglasses. And I'm convinced probably these women thinking of a come up would just be sending him this random crap. Let's see, video, 35-second video. So the first one was a 35-second video, two videos of a model having relations with an unidentified man, a 30-second video of a model and an identified man having relations. X. We have another video sent by text. This was 3 videos. He cropped and shortened the videos and sent different versions. 35 seconds. Video defended and Yeezy employee. What? No wonder she sued them employees too. Oh man, oh man. Video defended and a Yeezy employee having intercourse, followed by a text saying, what you think of this vid? 10-second video defended and another Yeezy employee having intercourse, shortened and cropped version of the previous video. So it's the same employee. Then a 19-second video, defendant and Yeezy employee having intercourse. This video above were followed by a text saying, I edit LOL. Defendant cropped his blank out of the frame because he said it did not look big enough to send to one of his friends. Okay. Kanye sent another video via text, 15-second video of model dancing naked, bending over with hands on the floor, spreading her cheeks to show her vajayjay and her place where the sun don't shine. A photo, which is a photo of a woman's boobies. And then sends a following text. Description of that text. Defendant sent screenshots of text between him and a Yeezy employee. I came so I love seeing your reaction while we blank. I want to blank your mom before she leaves. What? This was followed by a text from the defendant. I want you to watch me blank your mom. Oh my gosh. Jesus will not approve of this, my boy. All right, so another example of defendant's offensive and abusive conduct occurred at the Soho warehouse in Los Angeles in early 2022. During a studio session, a male and female guest arrived. Kanye West, aka Ye, asked the male guest if he would allow Kanye to have intercourse with a female guest. Ye told the male guest that in exchange for allowing him to have intercourse with the woman, the male guest could have intercourse with plaintiff. In an effort to persuade his male guest, Kanye stated that plaintiff has the great punani. Again, defendant was insinuating that he had previously had intercourse with plaintiff. Mm. In February, March 2022, in Miami for Donda 2 at a work dinner, Kanye followed plaintiff as she excused herself to the restroom. Kanye asked plaintiff if she would participate in a plaintiff declined. Kanye FaceTime plaintiff when plaintiff was at her home with a guest. Defendant had asked to have phone relations with plaintiff's friend. Plaintiff again declined and ended the phone call FaceTime. Hi, Gracefully Living. How are you doing? Thank you for joining. Kanye asked plaintiff to come to his hotel, which was Nobu in Malibu, California, because defendant said he needed plaintiff to go log him into his Netflix account. Once plaintiff arrived, defendant admitted that had plaintiff come to his hotel because he wanted a hug for his birthday. Now, when we first discussed this, he paid her $1 million salary for her to be available 24/7, and she accepted. I wouldn't accept that. I'm like 24/7. That's a little crazy. But you needed you couldn't get into your Netflix password. So that's how you called her over there to your hotel room only to tell her that you wanted a hug for your birthday. Oh, this is sad. Whew. Kanye would require plaintiff to coordinate Uber rides for women to meet with him. On such occasion, in August 2022, after plaintiff had arranged an Uber ride, Kanye and Bianca called plaintiff wanting to discuss the orgy. Now, a fivesome, y'all. I ain't never heard enough fine. So, oh my gosh. They had participated in the day before. So Bianca out there too. So Bianca probably knows what Kanye does, and she probably does her own thing, allegedly. They just out here doing any and everybody, allegedly. Hmm. In August 2022, at the Yeezy Gap office, Kanye West required plaintiff to remove her cardigan while she was in the office because he said it was covering too much. Later that evening at the office, Kanye asked Bianca and other female guests to perform oral on him and his male guests in the office changing room. During the same time period, Kanye asked assistant design assistants at the Yeezy Gap office why plaintiff would not have relations with him. Defendant was extremely upset and angry that plaintiff would or have blank with someone else but not him. Yeah, buddy. On a private overnight flight to Paris for the Yeezy fashion show with multiple other Yeezy LLC employees, Kanye texted plaintiffs and asked for a hug. Plaintiff said no. Defendant came out of his room on the plane and said he needed to talk to plaintiff. Once inside the room, the plaintiff shut the door. Wait, yeah, Kanye shut the door. So once she got inside the room, Kanye ended up shutting the door. Defendant was aware that doing so would trap the two of them inside as it's unable to be opened from the inside. That is wild. Defendant laid down on the bed and asked if he and plaintiff could talk. Plaintiff sat in a chair across from defendant. He did all of that under the covers until he fell asleep. Plaintiff was unable to leave as the door had locked and jammed behind her. Eventually, another employee saw a text from plaintiff and came and let plaintiff out of defendant's room. Ooh, I'm gonna take a break before I get to that part. Let's see. LP did say that Kanye become a lower version of Diddy. I totally agree. Gracefully living, happy to catch your live. Thank you. Glad that you're here. She also said she looks like a submissive. I have no doubt that Kim participated in some kinky roles as well. Mm, mm. That tells a lot about Kanye and who's surrounded by Kanye. This is crazy. All right, so we get to I. Kanye regularly called plaintiff under the guise of discussing work related topics. So you trying to disguise like, yeah, it's something about work, these paperworks, and then you drift on to something else. This is crazy. Defendant would nah during the phone conversation and would often ask plaintiff if she could hear or guess what he was doing. I Man, I can't see this. Kanye West would constantly ask about plaintiff's current and past relation life. Defendant would frequently demand to hear details and was particularly fixated on the size of these other men, her boyfriends. That's wild. Defendant would often tell plaintiff that he always wanted to have relationships with her and that he held these feelings for a very long time. Defendant also falsely boasted that he had intercourse with her or would insinuate to his friends, business partners, and music and fashion collaborators that he was having relations with the plaintiff. Hey, hey, Tamika. Hey. Gold Digger said, I think about his kids. Oh, yeah, how his kids will possibly one day read these court documents about their father. Yeah. And I'm pretty sure it's already on the news. So I can only imagine what I hope that Kim, it's not too much that you can do because these kids really are on social media all the time. So, if they don't watch TV, they're going to get it from Twitter or Instagram or whatever social media you see. Let's see. So this man just out here making up lies. Defendant Kanye West's obsession, fixation, and stalking of plaintiff continued even after plaintiff was wrongfully terminated. So he fired her. He fired her because he was upset he couldn't get none. And then after he fired her, he gonna go stalk her? Kanye, I know you ain't out here doing that, and you got a whole wife at home. Indeed, in late 2022, Kanye West moved into the building where plaintiff lived. After doing so, defendant's unprofessional and harassing conduct toward plaintiff continued. Plaintiff did not welcome or encourage these offensive acts, text, videos, and statements, nor did plaintiff condone defendant Kanye West's aforementioned offensive, demeaning, embarrassing, and abusing behavior. Instead, notwithstanding the harassment, discrimination, and abuse, plaintiff remained focused on performing her job as an executive assistant, personal assistant, and she remained as professional as possible. Why, you know what? It's crazy that let me see. So Tamika said, I'm not even shocked at this. I was really on the fence about this because I'm like, you see Kanye with the Sunday service. Now, with the Sunday service, he even did them wrong. So I wasn't thinking in terms of this nasty stuff. I'm just thinking about, okay, he's not paying people, things of that nature. So this right here is this a little wild to me. So pretty much what she's saying is through her whole employment with Kanye, she remained professional and she focused on doing what she was told that was morally and ethically right, not the other nasty stuff. She always remained professional, all right? So keep that in mind, y'all. Meanwhile, on or about September 13th, 2022, defendant Kanye West, an individual, and those 41 through 50, inclusive in each of them, offered plaintiff a well deserved promotion to the role of Chief of Staff for defendants Yeezy LLC, Yeezy Apparel, Yeezy Footwear, Yeezy Construction, and Kanye, as well as those 1 through 50, told plaintiff that she was getting an additional $3 million as a result of her well deserved promotion to Chief of Staff. Hmm. Thus, plaintiff's salary for working for defendants and each of them, the sum was now of $4 million. Because remember, she started at 1 million, and then just now he given her a $3 million raise, I would say, because she was promoted. Plaintiff and justifiably reliance on the representations of defendants and in each of the accepted new positions. So she accepted the new position and began performing services for defendants in each of them in her now chief of staff role. So you making $4 million a year and you're chief of staff for all of those entities. That's why she sued everybody and their mama that's associated with Yeezy. September 16, 2022, plaintiff contacted defendants in each of them and inquired if her raise would be paid in a lump sum or in installments. Defendants, however, did not respond. On October 11, 2022, defendants Kanye, an individual, as well as those 41 through 50, inclusive, and each of them, advised plaintiff that she would be paid in a full lump sum that day. So meaning that she was supposed to get her $3 million. That's what she wanted. However, they did not pay that girl. They did not pay that girl that 3 mil. So you're chief of whatever, chief of staff, and you're still making $1 million. I would have quit. Despite expressing their satisfaction with the plaintiff's job performance, defendants and each of them continued to fail to pay plaintiff as they had previously promised. In fact, on several occasions, defendants Kanye and those 41 through 50 inclusive and each of them. So when it says inclusive, that means all together and then each person. So they were doing that, telling her, promising her that they was going to pay her, and she still didn't. But anywho's, in an effort to continue to induce reliance on plaintiff's part, created a group text with the defendant's accountant and plaintiff, instructing that plaintiff be paid $3 million, but then stopping the wire payment of the money each time. So they put her in a group message and say, hey, can you go ahead and make a transaction, wire the $3 million to her, and then they'll stop it each time. That's wild. Meanwhile, plaintiff continued to rely on defendant's representation that she would be paid her stated salary and continue to perform her job responsibilities for defendants. Plaintiff also advanced many costs necessary for the performance of her services for defendants and each of them, including cell phone charges, meals, purchases, all at defendant's request and defendant's benefit. So even though she's getting paid $1 million a year, I'm assuming that it's on a monthly basis, every 2 weeks or whatever the case may be, she's paying out of her pocket this here. So it's like at the end of the year, instead of that $1 million, depending on their lifestyle and how much everything is, she's probably making little over 500,000. And then mind y'all, her get rid of her OnlyFans. So she's not making a lot of money. On or about October 21st, 2022, defendant and each of them terminated plaintiff's employment, offering plaintiff a severance of $3 million, which she accepted. So they terminated her employment. They told them, we're going to give you a severance package that includes $3 million. Defendants then reneged on their commitment to pay the severance to plaintiff. Thereafter, on or about October 2022, defendants and each of them asked plaintiff if she could perform some additional services for defendants, again promising and to pay plaintiff her severance, despite having wrongfully accused plaintiff of extortion. In reliance upon said representatives, plaintiff performed such services for defendants and each of them. She also advised defendants in response to their false accusations that the plaintiff engaged in extortion, that all she had done was requested that she be paid as promised and agreed by defendants. My thing right here, and I've actually worked in a firm where the accountant embezzled some money. Anytime you're going to accuse somebody of doing something, file a lawsuit. Y'all trying to hold this over this girl's head, and that's crazy. That is really crazy. To induce further reliance on plaintiff's part and secure their continued services, defendant on or about October 31st, 2022, again created another group text with the accountant and the plaintiff instructing that she be paid. Once again, she was never paid. So what I just read was all the facts of the case. This is what happened. So we seen that, she agreed to a salary of 1 million. That she was sent nasty texts and videos. She was also, encountered some instances with West doing some nasty stuff on the phone in front of her, wherever the case may be. He's in with it with his wife doing orgies, all this nasty, weird stuff. All right. Now we're going to go to the part where we break it down. Now it is 15 causes, and I'm going to try to get to the meat and potatoes of each cause. So the first cause of action, as we see, was the breach of oral contract. Oh, I'm glad they said this. So here, breach of oral contract. This girl had nothing in writing. She had absolutely nothing in writing. I don't care if you're working on a cash job. If you are getting hired, you need to have something in writing to show how much you are getting paid. See, these people know what to do to make people do the opposite. I just had one in court, in small claims court, but it's okay. In small claims court, actually won a judgment because who he worked for, they never signed the agreement, but he did have some text messages and stuff that actually saved him. And I was able to draft a complaint and supplemental documents that he can use in court. And thank the Lord, he was able to retain some of his money, not all of it. Now, if he had a contract, a written agreement that shows, okay, you getting paid for this, and this, then that would have, and presented that to the judge. That judge would probably say, okay, you have it here in writing. That's how much they were supposed to pay you. They didn't pay you. Here you go. Breach of oral contract. I don't know how you are going to prove that unless you have the text messages that show, okay, we're going to send you the $3 million. Like if they have that in the text message and say, hey, where's my severance package? So if it's like a timeline, that can help in her benefit. But I don't see how they're going to prove this. Gracefully Living said, just wondering why she put up with this for so long. This is starting to seem like a Me Too part two. Yes, in a sense, but then no, I would say only because, how can I say this? A lot of these women and probably some men see these artists like a P. Diddy or a Kanye or Jay-Z and thinking, okay, I can upgrade, I can level up if I do the bare minimum. When I say do the bare minimum, I didn't mean that. More like if I could be a personal assistant, if I could start at an assistant level position, I can move on up. And I'm pretty sure that's what she did. Now, the fact that when she got with Kanye, he made her talking about, I want you to be more godlike, but then made her, delete her OnlyFans. That was a big chunk of her income that was taken away. And so for probably a whole year or two, she was promised these funds. She is paying out for herself, paying meals and trips and all this other stuff. So she wasn't even getting reimbursed for that. That's the wild part. But you guys still failed to pay her. So I'm interested to see how the breach of oral contract is going to work out. But going here, defendants in each of them breached their agreements in that they have failed to pay all the wages and monies due to plaintiff per the terms of their oral agreement. As a result, defense breach of the agreements, plaintiff has been damaged in the sum of at least $4 million. So for a breach contract, they are wanting to get nothing less than $4 million for the breach of contract. Second cause of action we have is, excuse me, wrongful termination in the violation of public policy against defendants. Plaintiff incorporates all of these allegations above as true, but now we're going to figure out why. Well, we all know why she was wrongfully terminated. In my eyes, it's like, okay, she didn't do what Kanye wanted her to do. We're going to have to let you go because we need a yes, ma'am, or yes, sir. Let's see. Gracefully said, does she say there was a time frame she was to work before payment? No. Okay, so that was her yearly so how can I say this? The $1 million at the beginning, that was her salary to be a executive assistant and a personal assistant to Kanye. I don't know. I wish it broke down to see how much she gets paid, whether it's on a weekly basis, a monthly basis, every 2 weeks. I just don't know. The $3 million is kind of like a bonus. So, when you get a promotion, they'd be like, hey, I don't know if, well, she did ask for a lump sum. So I'm assuming as soon as she accepted that position as chief of staff, she should have got her $3 million in the bank probably the next day. So, yeah. Yes. So Ramona said, did you say this was oral? Was anything signed? Yep. So that is a oral document. Well, it was an oral agreement. It was oral. So nothing was signed. Because if it was signed, it would just be a regular breach of contract, and they would have a copy of that, but they didn't, which is crazy. Let's see. Wow, the bag is large. Who child? Yes, it is. Kanye got that money, but well, when I say Kanye got that money, I don't know. He probably had that money. So we shall see. We shall see. All right. All right. So the next session, the second cause of action was the wrongful termination. So, she was wrongfully terminated, but they said, we're going to give you a severance package of $3 million, and she still did not get that. But this is just part of being wrongfully terminated. So here it says plaintiff was wrongfully terminated as described above. The above described conduct of defendants constitutes wrongful termination of plaintiff in violation of public policy embodied in various statutes and other laws, including but not necessarily limited to the Fair Employment and Housing Act, which prohibits gender discrimination, which is under the California Labor Code section 6310, 6311, and the Government Code section 12940. As a result of defendant's discriminatory, retaliatory, and unlawful actions against her, plaintiff has suffered and continues to suffer damages in the form of lost wages and other employment benefits and severe emotional and physical distress, the exact amount of which will be proven at trial. If this case goes to trial, um, I think it's going to be a good case. That's in my opinion. Uh, Even though she does have an oral contract, it dealt transactions where they were trying to wire her $3 million and they reneged on that and things of that nature. So you can only imagine. You had me let go of my OnlyFans. I lost a big chunk of my salary, my income for a year. I think she has a good chance on this. Thing was in writing. So Ramona asked, was the severance pay in writing? It was not in writing, but there was that they had, and messages was exchanged where the accountant was to. So somebody advised the accountant to wire the $3 million to her, and so they put it in motion, but then they stopped it dead in its tracks. You also asked, technically, is this his word against hers? Stayed a whole year without pay. Yeah, but I'm pretty sure that this is what the attorneys is going to fight. I mean, she does have, text messages and so she's not going to leave with nothing. And if it goes to trial, she's going to leave with something. But I really really think that they're going to hash this out during mediation. But first they have to get all the evidence. So we still have to wait for Kanye to see exactly what his response is going to be regarding this lawsuit. All right, so on May 28, 2020, plaintiff filed the Civil Rights Department, State of California, formerly the California Department of Fair Employment and Housing, which is the DFEH, a complaint charging defendants with discrimination, harassment, retaliation, and other claims in violation of the California Fair Employment and Housing Act, which is FEHA. In Texas, we have the EEOC, Equal Opportunity, blase, blase, blase. And so what happens is when you file a complaint, you pretty much tell them everything, all the facts of the case, and they will determine if you have the right to sue. That's normally how it's supposed to work during wrongful termination. So, in the event that anybody is wrongfully terminated, see what your employment laws are. You can go, if you're in Cali, you have the FEHA. Everywhere else, it might be the Employment Equal Opportunity Employment Commission. And then some states, I forgot what the terminology, but just Google wrongful termination EEOC and it'll pop up for your state. But anywho's, when you file a complaint with them, they review the case, they'll do some investigation, and then if they feel that you do have a case, then they'll send you a right to sue letter. Then you take that right to sue letter and you find you an attorney that is willing to take your case, and then you will attach your right to sue letter with the complaint that you file in court. That's normally how that works. And this is exactly what she did. Defendants in each of them acted for the purpose of causing plaintiff to suffer financial loss and severe emotional distress and physical distress, and are guilty of oppression and malice justifying an award of exemplary and punitive damages. I have to agree on this one. I'm not on his side, but based off of what he made her do, and the income that she lost, that everybody knows when you go from making money to no money, that can take a toll on you. So I can see that this is going somewhere as well. Third cause of action for the harassment in the hostile work environment against defendants. So for this one, still a violation of FEHA. As a result of defendant's unlawful actions against her, plaintiff has suffered and continues to suffer in the form of lost wages and other employment benefits with severe emotional and physical distress, the exact amount of which will be proven at trial. Fourth cause of action, the retaliation. So let's see. So plaintiff reported and complained about discriminatory, harassing, and hostile work environment to which she was subjected. Defendants of each of this discriminated, harassed, and retaliated against plaintiff as a result of her complaints and her refusal to have relations with Kanye West. Ultimately, defendant terminated her employment in retaliation for her complaints and refusal to have relations. This is legitimate here. She has, so because now, how can I say this? I'm not sure who she made complaints to. That's one thing. But if he came out and if other people can witness that she was terminated because she refused to have relations with this man, this would be a good, this section right here is legit. She has suffered and continues to suffer damages in the form of lost wages, and this is going to be repetitive. We're going to on each cause of action because, like I said in the last video, we got to beef it up some way. The fifth cause of action, gender discrimination. Once again, violated the FEHA. She is going to continue to suffer damages, lost wages, employment benefits, and she's going to have severe emotional and physical distress. So all of this she has to prove at trial. Yep. Sixth cause of action, failed to prevent discrimination and retaliation and harassment against. So defendants and each of them failed to take reasonable and require steps to put in place policies and procedures designed to prevent discrimination, harassment, and retaliation. Indeed, defendants fail to prevent these unlawful workplace practices and are indifferent to their obligations as employers to provide a safe workplace. Oh my God, this is, I get so excited when I talk about this because I do this all day. So if Kanye does so for each of those entities, and you guys know that, especially if you work somewhere, you have a handbook, you have an HR, they have policies in place, the what they call it, the open door policy. If there's something going on, you can feel free to come talk to HR, file a complaint, whatever the case may be. Kanye didn't have that. Kanye didn't have that, obviously, because if he did, then we wouldn't be here today with all of this. So he, as well as those companies, failed to have something in place to protect their employees. That's what makes it a hostile work environment. It's not a safe environment. When she was harassed and discriminated against, who did she have to go to? I'm going to look and see how the organizational structure for each of these companies are, and I'll definitely get back to you guys. But you have your CEO, your CFO, your HR department, then your employees. So I'm curious how that up is actually set up with these Yeezy companies. Go to these comments right quick. I think I read this one already. All right, yes, I read. Said, first of all, she underbidded herself by deleting her OnlyFans. Regardless of the person, job you're in business with, everything needs to be in writing first and foremost, signed by all participants. I I agree. I really agree with that. Kanye said no blowing over here. He's like, I ain't gonna have no part. Y'all can't go snitch on me. Y'all can't go, but he messed himself up. He messed himself up on this one. All right, so that was the sixth one. Once again, she suffered damages, physical, emotional, all that good stuff. Quantum merit. Merit. Let's see. For this one, within the last 2 years, plaintiff rendered work, labor, labor, and services to defendants, and each of them at the special request of defendants, for which defendants then and their promise to pay plaintiff the reasonable values of such services. So all of the meals, all of the Uber trips, all of those stuff, they asked her to do these things, but didn't pay her. You're going to her up to chief of staff, which I'm assuming is a very high position, but you didn't pay her. She was a dedicated employee because I've been with a quit. At all times, the above services were and are of the reasonable value of no less than 4 million. So for this cause, she's not looking for anything less than 4 mil, which was agreed upon by the defendant and the plaintiff. I just pray that those text messages are sufficient, that shows, okay, they were trying to send her this money, but they ain't pay her this money. I hope that they are sufficient to where it will get her over her $4 million. Gold Digger said, this is so sad, Cassandra, and yes, you do need an HR department so this type of mess doesn't happen. Abuse of power position by Kanye. That is correct. That is very correct. No part of the sum was paid after she had constantly demanded for payment. Eighth cause of act, unjust enrichment against all defendants. As a result of the breaches by and wrongful acts of defendant in each of them, as described in this complaint, defendants have been unjustly enriched at the expense of the plaintiff. Defendants have derived and continue to derive a benefit from failing to perform their contractual obligations pursuant to the parties' agreement at set forth above. So once again, it's going back to that oral contract. You guys failed to pay me what y'all promised y'all was going to pay me. Defendants are under an obligation to pay plaintiff for forthwith all amounts by which they have been unjust, which sum is not less than identified above. So once again, nothing less than 4 mil. LP said it is very important to have a paper trail, emails, and other reliable documentation in cases like this. Yes, it is. I don't care if you are going to the mechanic shop and them people tell you, okay, your repair is $3,000. You better get that in writing. It's the smallest things that you think that you don't know, need to have in writing. So yes, save all your texts, your emails. There are apps out there that you can actually save your text messages and stuff on. But like I said earlier, if you ever in a lawsuit, we can get those records. So you don't have to worry about it. The ninth cause of action, she also sued them for fraud. What they did, defendants in each of them made statements to the plaintiff as identified in paragraphs 7 and 8, 10 through 15 of this complaint. They knew that they were false and that they had no intention of performing as they had so promised. Rather, such representations were made with an intent to deceive plaintiff and secure services and contributions of money from her. Plaintiff, meanwhile, justifiably relied on the misrepresentations of the defendants in each of them and continued by the service. So it's crazy because now, as I'm reading this, I'm thinking in my head. So you promise her a salary of $1 million to be a personal assistant, executive assistant for all your businesses, and she had to work 24/7 whenever you needed her. But in the interim, she has to pay out of pocket a lot of those expenses. So what is she really making? Then you get boosted up or promoted to chief of staff or whoever, and you're supposed to get $3 million. But once again, I'm assuming when you get a promotion, that means more work. So more expenses that are paid. So how much did she really make? Probably nothing. Very sad. 10th cause of action, all against all defendants for failure to pay wages, which is a violation of the labor code. We all know that. A strong public policy favors full and prompt payment of wages due to an employee. It has been recognized long been recognized that wages are not ordinary debts, that they may be preferred over other claims, and that because of the economic position of the average worker, in particular, his dependence on wages for the necessities of life, for himself and his family, it is essential to public welfare and that he receive his pay when it is due. And so I love these cases when they actually have to reference another case law, because just showing you that there's other cases out there, but you guys need to take into effect of how serious this is. You didn't pay this girl. People need their money. That's their life. You got to pay your rent and other necessities. I don't know if she has a family. I went on her Instagram and I just seen her. But you got to pay car, you got to pay insurance. There's a lot of things that you need. You can't wait to be paid next year or next month. When you're supposed to be paid, I need my stuff either today or by early tomorrow morning. Okay. LP said she was too excited about who she was working for and felt gullible to being a fan. God don't like ugly, and Kanye will reap what he sowed. He took advantage of her, period. I totally agree with that. And that's what I said at the beginning. I think because it was Kanye, she got too excited and said, okay, I'm going to go ahead and ride for this. And then found out that the grass was not greener on the other side. Tragic. Wages include all amounts for labor performed by employees of every description, whether the amount is fixed or ascertained by a sort of time, task, piece, commission basis, or other method of calculation. Plaintiff, as set forth above, has not been paid all earned wages. This is a violation of the labor code, and each of those people in Conway knew that, but they still refuse to pay this girl based off of her performance. She performed to her obligations, but yet they did not perform to their obligations, which was to pay her. So they definitely are in violation of the code. Let's see here. Plaintiff is entitled to statutory penalties, prejudgment interest, and attorney fees. In addition, failure to pay wages when due also subjects the employer to civil penalties payable to the state of California in the following amounts for an initial violation: a penalty of $100 for each failure to pay each employee, and each subsequent or willful violation, a penalty of $200 for each failure to pay each employee, plus 25% of the amount unlawfully withheld. That's out. I need to look at Texas codes, labor codes, to see what the penalties are. So not only do you have to pay what you owe her, plus penalties, the statutory penalties, the prejudgment interest, and attorney fees, you also have to pay penalties to the state of California. That's crazy. I love it. I love it. I love it. 11th cause of action. We almost there, y'all. Waiting time penalties. So yeah, this girl had to wait for her money. You don't think we're gonna sue for that? During the relevant and statutory time, defendants and each of them have failed to pay all earned wages to plaintiff during his employment with defendants. They meant to say her. Defendants have the monies to pay plaintiff after all defendants has proclaimed himself to be the richest black man ever. I knew they was gonna put that in there. Yeah. So man, you said you was the richest black man ever, but yet you cannot pay this girl. That's wild. As a consequence of defendant's willful failure to pay wages due to plaintiff is entitled to recover from defendants an additional sum as a penalty pursuant to the Labor Code Section 203 in amounts plus interest thereon, according to proof at trial. So once they prove that the plaintiff did not get paid, if they go to trial and it is proven that he did not pay her, she's not just going to get that recovery from, which she's also going to get an additional sum for. It's like pain and suffering. It's like, okay, you didn't get paid for this. We're going to give you this plus a little bit more because you had to go through all of this. 12th cause of action, failure to provide accurate wage statements. Ooh. So let's see. Okay. So plaintiff is informed and believes and based thereon alleges that defendants in each of them have knowingly and intentionally failed to provide accurate itemized wage statements to plaintiff. So a pay stub. Okay. So I hope they didn't alter the pay stubs and saying like, okay, we getting sued. So let me go ahead and drop a little pay stub to show that she's getting paid weekly or whatever the case may be. But in this case, I don't even think they even provided her with a wage statement to show how much you made for that week or that month or that year. Well, I just want to say weeks, or even if you get paid, every Friday or bi-weekly or every 2 weeks, they didn't provide these statements to her. That is also in relation to the Labor Code Section 226. Defendants in so as a result of this action, defendants in each of them are liable to plaintiff for penalties as provided by law, reasonable attorney fees, and costs pursuant to the Labor Code. In addition, they are liable for civil penalties pursuant to Labor Code for each of those violations. Boy, it just gets worse and worse. Failure to reimburse business expenses. So you got this child out here using her little $1 million salary after she done got rid of her OnlyFans and she's paying all this stuff and you didn't even reimburse her? That's crazy. So that is a violation under the California Labor Code Section 2802, where employers must reimburse employees for all necessary expenditures or losses incurred by the employee in direct consequence of the discharge of his or her duties or his or her obedience to the direction of the employer. So they failed to compensate her for all the reasonable expenses and all the liable for such expenses plus the penalties of Labor Code sections 1197.1. Oh, and 2802. 14th cause of action, intentional infliction of emotional distress. Like I said, we always going to put that in there to make these people feel very, very bad for the plaintiff. But what happens is, I'm just going to read 70. The conduct of defendants and each of them as alleged in this complaint was at all times extreme and outrageous and carried on by the defendants and each of them with either an intention to cause emotional distress or with reckless disregard of the probability of causing emotional distress. As a result of the conduct of defendants and each of them, as alleged herein, plaintiff has severed suffered severe emotional suffering. So emotional damage, that's what she suffered. Financial loss, emotional stress, physical distress, guilty of oppression and malice justifying an award, exemplary and punitive damages. Whew, man. And this is the last cause of action, y'all. Failure to produce, make available for inspection employment records in violation of labor code. So what I am assuming that's happened, give me 1 second because my puppies are just driving me insane. 1 second, guys. Whew. If somebody would have told me that two puppies was going to be a hassle, I would have just stuck with my Yorkie. Okay, let's get back into this. Almost finished. So going into the 15th cause of action, what was I gonna say? Oh yeah, failure to produce, make available for inspection employment records in violation of labor code. So remember when I told you guys that anytime you're dealing with the wrongful termination and you present to your department, it's a state department, similar to the Equal Opportunity Employment uh, Commission. What they do is they investigate, they reach out to the company, and they I don't well, how can I say this? Yeah, they investigate. They'll reach out to the company and request certain documentation. So here they requested her employment records. So we all know what comes when you work for an employer. You know, you fill out an application, you fill out your W-4s or nine, no, W-4s, give your direct deposit or however you want to get paid. You do all of that. That's like included in your employment record, along with any other, like if you made a report to HR with complaints, all of that goes into your file. So when the FIHA, when they investigated and they reached out to Kanye and his subsidiaries, these little companies, I'm pretty sure that they requested these records, but they didn't have anything to provide. So that's why in this complaint, they also included a cause of action for failing to produce. So 74 says plaintiff requested vis-a-vis communication through her counsel, various employment records she is entitled pursuant to California Labor Code. To date, defendants and each of them have failed to comply and provide plaintiff with such records that is required by code. So because they failed to do this, she seeks statutory penalties, injunctive relief, and attorney's fees as authorized by law. So, wherefore a plaintiff prays for all of those 15 cause of action. Remember, she's not accepting anything less than $4 million. She prays for compensatory damages according of proof and prejudgment and post-judgment interest, exemplary and punitive damages, payment for attorney's fees, statutory penalties under the labor code, injunction relief, prejudgment interest, costs for the suit, and whichever relief that the court may deem proper. And that's it. That is it. So in my opinion, I don't know the total of what she is asking for, but I do know that if they look at whatever evidence they have, including the text message, possibly get some witness statements, affidavits from witnesses or other employees that's willing to act on her behalf, who knows? She has a good case. she has a good case. Now, how much she may get, I don't know. But based off of the complaint, she's not accepting anything than less than $4 million. Nothing less. All righty. So that is it. That is it. That is it. That is it. Let me see these comments right quick and then I'll let you guys get on out of here. Let's see. Let's see. All right, I'll start here. So Miss Gold Digger said never heard of a work now and pay later job. Just saying. Okay. Run me my coins now. Okay. And one thing I did learn, see, I work for myself, so it's a little bit different. I have to get funds up front because I've had so many people burn me. So if they say, hey, I need a petition or, family law, I draft them all up, but it's a flat fee. Either half now or and the remainder due before I even file a lawsuit. That's how I work. But yeah, I'm never working for free, ever. LP said, okay, Gold Digger, don't play with my money ever. I feel you guys on that. Miss Gold Digger said, that's right. LP messing with people's real life here with no payback. Yeah, they gonna get a payback, a lawsuit. LP, her nature of work had nothing to do with paying what was owed to her. I would have texted him asking for a specific amount and when it would be deposited in my account. On two occasions, there was a group text message that was created that had her and his accountant in it and other defendants, and they were text messaging and they say, hey, I need for you to wire her $3 million. So the text messages are there, which is great. That's if they can utilize that, I can see this going somewhere, honestly, because I know it was an oral contract, but that's why I say you have to have some type of tangible evidence for us to read, or not us, but the judge to say, okay, even though you don't have an oral contract, at least you do have proof via text message that, okay, you were supposed to get paid this. They promised this. You didn't get paid this. And I'm pretty sure they're going to get bank statements. They're going to get the statements from the accountants, Kanye's accountants bank, showing, because obviously they're going to show that them sending a wire and that it stopped dead in their tracks. And somebody's going to question it. Hopefully her good attorney will question that. Gracefully Living said, wonder if he's going to blame payroll or personal accountant. Love to see his response to all of this. Me too. We don't even know, but I'm curious. Do what you do, Cassandra. I wholeheartedly respect and appreciate you for educating us on your personal time. Thank you so much. Oh, you're so welcome. Thank you for joining and watching. While I hope she gets it too, I agree. This was a good read. Thanks. You are so welcome, Miss Gracefully Living. Gold Digger says, yes, that's the way to do it, Cassandra. Get your coin up front. You work hard. Yes, ma'am. I don't play now. I don't play now. 2 years ago, they could have got me, but I was standing on business 2024. And LP say, okay, that was very helpful. Awesome. Well, thank you guys for tuning in and enjoy the rest of your day. If you are off, don't forget to hit the like button, share it if you can, subscribe if you haven't subscribed, and I will catch you guys on the next run. I am planning on doing some more content. I made a post the other week on what type of cases did you guys want to, go into. People said Blueface, NBA Youngboy, Tory Lanez, Young Thug, and I haven't gotten to the latter, NBA Youngboy, Tory Lanez, or Young Thug, but I've been tracking Blueface since January, so I have like a whole timeline of everything. So I am excited to put out some more content this week for you guys' pleasure. And once again, thank you guys for coming over. I will see you on the next go round. Peace out, y'all.